I want to talk about Second Amendment procedure, mootness, and standing in the context of the statement, proudly so, and I'm happy that this happened, by the Second Amendment Foundation that said they would stand up and support and defend the Second Amendment rights of President Donald Trump because he is now a convicted felon under New York state law, but nevertheless, he technically is a convicted state felon under New York law, and the Second Amendment Foundation has stood up and says that they will defend and protect his Second Amendment rights if Donald Trump loses his ability to have a concealed carry permit, for example, in New York City. Let's break it down. There's some important things we need to talk about using this as our context. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of the brand new best-selling book, I'm happy to say, Israel Disarmed, What the 10/7 Attacks Teach Americans About the Right to Bear Arms. A lot of important gun-related history going back thousands of years of governments disarming, for example, the Jews, and the lessons, rightly and wrongly, that the Jews took away from this that ultimately cost them on, in my view, on 10/7 when the terrorists attacked. We'll talk more about that. A lot of critically important historical and other lessons that we Americans must learn from to protect our constitutional rights, our Bill of Rights, and yes, indeed, our right to keep and bear arms. Very important. All right, folks, so you all know, you've seen me on Fox News, I'm sure you're all aware of this from 1,000 sources, that President Donald Trump was convicted, in my view, in a sham case, of 34 counts of bookkeeping record falsification. We've talked about why this is utterly insane and stupid. Everything was wrong about this, including, as I predicted, the way they were going to insist upon the jury ruling against Donald Trump. Skewed, improperly drafted jury instructions that basically told the jury to convict. Nevertheless, this video is not about that case. We've talked a little bit about that. What this case is about is the outcome of that, and whether or not President Donald Trump loses his Second Amendment rights, including, for example, will and can New York City pull from him, if he even still has this, his concealed carry permit, which he has had for many decades, as I understand it, based on the reporting. Now, to begin with, we all know that the federal law 18 U.S.C. 922 G1 says that anyone that's been convicted of a felony is not allowed to possess firearms. We also know that the definition, and this is very important, a lot of people don't understand what I'm about to say, so this is very important that you understand the games that the anti-gunners play, because this is a huge one that is kind of inside baseball, nuanced legal games that people don't fully appreciate what's going on here. And that is this. 922 G1 says people who've been convicted in a felony cannot possess guns. That seems straightforward. When people hear that, ordinary people think that means if you've been convicted of like rape, robbery, murder, terrorism, you lose your right to keep and bear arms, and people are basically, as a concept, kind of on board with that as a general matter, because people generally don't want violent thugs and violent terrorists to have guns. But the game that's been played by Congress is that the definition of what a felon is so broad under the federal statute that it encompasses all sorts of things, including people that have been convicted of misdemeanors in certain cases. Specifically, federal law defines felony, as in a convicted felony under 922 G1, as someone who's been convicted either because they pled guilty or found guilty after a trial in front of a judge or found guilty after a trial in front of a jury. They have been found guilty of either a felony where you could under the statute which you were convicted of, you could theoretically have gone to prison or been sentenced to prison for more than 1 year, even if you never serve a day in prison. Did you hear what I just said? You lose your right to keep and bear arms if you've been convicted of a quote-unquote felony as defined as a felonious crime or something that's labeled a felony by the government, where you, under the sentencing guidelines or the sentencing rules for that crime, could have been sentenced to more than 1 year in prison, even if you're not sentenced ultimately to any days in prison. That is a convicted felon. You lose your gun rights for life under 922G1. It gets even more insane than that. That is, if you've been convicted of some misdemeanors, which are historically been viewed as minor crimes. They're crimes, but they're sort of minor in the grand scheme of things. If you've been convicted of a misdemeanor crime, and you could have theoretically been sentenced to prison under that misdemeanor crime you pled guilty to or were convicted of. You could have theoretically been sentenced to more than 2 years in prison, even if you actually are not, you're not sentenced to a single day in prison. Again, if you've been convicted of a misdemeanor where you could have, under that statute you were convicted under, been sentenced to prison for more than 2 years, you are a felon under and for the purposes of 18 U.S.C. 922G1. So as a consequence, and don't quote me on the law here, but I think I'm right. This is what I've been told by people in Massachusetts, for example. The first time DUI, and no, you should not drive drunk or anything like that. I agree. Nevertheless, a one-time DUI offender in Massachusetts, because in theory under that statute, you could be sentenced to more than 2 years in prison for a first-time DUI offense with no victims, no crash, no nothing. You lose your gun rights for life, for example. One DUI in Massachusetts, so I've been told. You'll check me out legally if you need to, but this, whether it's true or not in Massachusetts, this is the concept. So what happens is these anti-gun blue states have every incentive to make every single minor crime in their state punishable by more than 2 years in prison, understanding that the judges and the prosecutors in the system are never going to actually ask for that or want that. They don't care about that. All they want is to make sure that every single person convicted of a jaywalking offense or these other offenses where the statute says more than 2 years in prison is possible, they disarm you. Okay, so that's very important to understand that. Now, as to President Trump, Donald Trump has been convicted of these 34 counts. If this was any other person on the planet, not only would this case have not been brought, this was a cobbled together theory, makes no sense. We're not going to get into this again. But the bottom line is that odds of, if he's sentenced to any days in prison, it will be entirely political because this judge, Judge Marchand, doesn't want Donald Trump on the campaign trail. He wants to embarrass Trump and keep him out of Milwaukee for the RNC convention. That's what this is about, lawfare. There's no doubt this is lawfare. But the point is that let us assume for the sake of argument that Juan Marchand, the judge there, actually sentences Donald Trump to nothing other than like a fine. No prison, no home confinement, no nothing. Let's assume it's just a fine. It doesn't matter for the purposes of 18 U.S.C. 922G1 because he is still a convicted felon, regardless of what the ultimate sentence actually is as applied to Donald Trump. So, but because he in theory could go to prison for each count more than a year, i.e. 4 years, I believe, under New York law, that is definitely a felony as defined by 18 U.S.C. 922G1, okay? So he will, under federal law, lose his right to keep and bear arms. So with that context in mind, the Second Amendment Foundation has come out and said they will defend Donald Trump's gun rights. And that's great. But what does that mean exactly? Well, first of all, let's be very clear about that. Even though I totally support the Second Amendment Foundation, I think they do great work. The Second Amendment Foundation by itself is not legally able to defend Donald Trump's gun rights. And what I mean by that is you get into constitutional or legal procedures. Remember how I've taught you that you got to understand to fight for the Second Amendment, not just the substance of Second Amendment law, substance being what is the Second Amendment, how do you interpret it, how does it apply to a sensitive place case, what does the Second Amendment mean, is it an individual right? Those are substantive questions about the meaning of the law. You also want to understand, if you want to be super geeky, the process by which a case moves through the system, the process whereby the sausage gets made. Now, in federal court, under the United States Constitution, this is a constitutional issue. This is not a made-up issue. This is a constitutional issue. Article 3 of the U.S. Constitution creates the Supreme Court and any inferior courts that Congress wants to create, which is the lower courts. And under Article 3, it says that federal courts are courts of limited jurisdiction, which means their jurisdiction is limited to only what the Constitution provides for. And the Constitution provides for things that are cases and controversies. Now, cases and controversies have been interpreted over the years to mean an actual fight over a legal issue where a remedy is available. I'm suing you to get money from you because you breached the contract. I'm suing you because you took away my Second Amendment rights and I want money and my gun rights back, whatever it is. There's an actual controversy. It's not just a debate over whether or not the Boston Bruins are the best hockey team or something like that. No, it's an actual legal fight where there's a remedy available at the end for one party or the other. An actual case in controversy. And there's two concepts that go into that at least. One is the notion of standing. Standing means that you are standing in the shoes of someone that has been injured or will be injured or something like that. In the case of the Second Amendment Foundation saying they will fight for Donald Trump's gun rights, I'm using this as an example to teach you that the Second Amendment Foundation cannot go into court on behalf of Donald Trump without Donald Trump to fight for Donald Trump's gun rights, because the Second Amendment Foundation would not have what's known as standing, because they're not the ones that would be directly impacted by virtue of Donald Trump losing his right to keep and bear arms all across the country, or his losing his concealed carry permit if he still has one in New York City. I'm not even sure he would have a concealed carry permit given he has Secret Service protection, and those things periodically have to be renewed. I'm just skeptical he even has one, but set that issue aside. Maybe he does. I don't know. I'm guessing he doesn't, but maybe he does. Okay? So the first thing is, for the Second Amendment Foundation to be able to defend Donald Trump would have to be the one that is asserting his Second Amendment rights, and then Second Amendment Foundation can come in there and represent him legally, or maybe as supporting amicus or something like that. But Donald Trump himself has to be the one to vindicate Donald Trump's rights in order to have, because without that, he doesn't have standing. And if you don't have standing in a federal case, you don't have a case or controversy. And if you don't have a case or controversy under Article 3 of the U.S. Constitution, the federal courts lack the legal authority to hear the case at all. Now, by the way, when you had the election fight, and at some point I should do a whole video on the 2020 election issues and the legal issues, but not for today. I should at some point. I got a lot to say about that. But with that said, a lot of those cases brought involving the election of 2020 were dismissed for a lack of standing, because it said the people that were suing were not directly injured. That was the argument, at least these courts made. So almost all those cases brought involving the 2020 election fight were dismissed for a lack of standing, because no standing means no case or controversy. No case or controversy means a federal court lacks the authority under the Constitution to act on the case. So that's the issue with standing here. Now, the other thing I want to bring to your attention, again, this is a super geeky video, but I want you to understand that, because to make you the smartest people in the room so that you can defeat a liberal law professor or a liberal lawyer in a discussion, I will give you the information that you can do that, okay? You can do that, because we're on the right side of history and law and whatnot. So I will train you, but some of this is a little geeky, but I don't want you to get tripped up. The other concept beyond standing is mootness. Now, mootness is simply a related concept that says that a case can be moot. And for example, let's say I sue to get into a university, and I say they discriminate against me on the basis of race. I want to get into the university. My only remedy I want is to get into the university, and they don't let me in. And then finally, after I sue, they let me into the university and say, okay, fine, we're going to let you in. Well, now, conceptually, that case is now moot. Set aside money damages for our example, but the case is now moot, right? Because all I really wanted was to get into the university. Now they let me in. Now I'm in. The case is moot because the remedy I sought, I want to be in the university, I now have, so the case has been mooted, okay? So the reason why I bring this up is, if Donald Trump, for example, no longer has a concealed carry permit in New York City because he let it lapse because he doesn't need it anymore because he's got Secret Service for the rest of his life, it's moot in the sense that he is not going to have a basis for getting that concealed carry permit because it's a moot point because he doesn't even have it anymore and he doesn't want it anymore because he's got Secret Service protection, which functions like a full-time concealed carry license. So in that context, one could argue that the case over whether or not he has a right to his concealed carry permit in New York City is a moot point because he let it lapse because he doesn't need it anymore or he doesn't want it. So the issue is moot. It's a moot point. The point doesn't matter anymore. Okay, so with that said, you have the doctrine of standing, which I just went over, and the doctrine of mootness. Give you another example in the Second Amendment context. You may remember many years ago in the first NYSERPA case, it went to the U.S. Supreme Court involving a New York City rule about carrying guns to a gun range outside of New York City. And that case was ultimately ruled to be moot because between the time the U.S. Supreme Court granted cert in that case and the time it was actually decided, New York City and New York State had both changed the laws dramatically to moot out the case. And the Supreme Court decided that indeed the case was moot, and that's another example of the doctrine of mootness. If a case is actually moot, you don't have a case or controversy under Article 3, and the case is not allowed to be in federal court. So with all that said, this is a long-winded way, but a geeky way of explaining in detail why the Second Amendment Foundation, while they are to be applauded for trying to defend the rights of Donald Trump and his Second Amendment rights, in the real world, the only way they can do that is if Donald Trump himself is willing to go to court and fight over this, and then the Second Amendment Foundation and their counsel could, if Donald Trump wanted, go in there and either represent Donald Trump, or if Donald Trump did not retain them, then the Second Amendment Foundation and their lawyers could theoretically file like amicus briefs and whatnot and show their support in that way. But the Second Amendment Foundation could not legally go into court on behalf of Donald Trump without Donald Trump being involved because they would almost certainly lack standing and or the issue might be moot if Donald Trump no longer has the license, and then it's a moot point. And either way, no standing, no mootness means no case or controversy under Article 3. The case cannot be brought in federal court and it would be dismissed on jurisdictional grounds. All right, folks, so there you have it, a little bit of information here today. Don't forget to follow me on X at 4 Boxes Diner. We have 16,000 subscribers, and that's growing over there. A lot more Second Amendment news beyond what I can do here. Don't forget to follow me and refollow me. We're trying to still get to 150,000 followers here, subscribers here on YouTube. And, of course, don't forget to check out my book on Amazon, Israel Disarm, What the 10/7 Attack teaches Americans about the right to bear arms. A lot of critical Second Amendment information about the right to bear arms, not just here in the United States, but in Israel and around the world. Check it out. It's a short read. I think you'll like it. All right, folks, we'll talk to you soon. We'll see you again soon here. Yes, indeed, at the 4 Boxes Diner.
Orders up. Table 2A.